You want me to?
We're back. We're starting again.
All right, we are back on the record. Thanks everyone for making it back. Now I'm going to turn to contention 2, the Unit 1 reactor pressure vessel embrittlement. Reactor pressure vessel, or RPV. Ms. Curran, we read contention 2 as raising a safety contention claiming that PG&E's plan to monitor or manage the embrittlement issues related to Unit 1 reactor pressure vessel embrittlement is inadequate. Is that a correct reading of contention 2?
Yes.
And just to confirm, this contention is limited to the Unit 1 RPV, correct?
That's correct.
Now, we spent some time during contention 1 talking about CLB. Do the petitioners agree that a nuclear power plant's CLB is not within the scope of a safety contention on a license renewal proceeding?
As a general matter, yes.
Reading pages 16 and 17 of the petition, Dr. McDonald's opinion is summarized as saying that the proposed aging management program for the RPV, which Dr. McDonald opines is inadequate, quote, relies heavily upon and perpetuates the pre-existing and inadequate surveillance program that PG&E has used during the decades-old initial operating license period, close quote. Petitioners then go on and outline purported deficiencies, ostensibly of the RPV aging management program. And then Dr. McDonald, or the petitioners, conclude, quote, taking all of these deficiencies into account, Dr. McDonald concludes that the NRC must reject PG&E's license renewal application because it relies on this outdated pre-existing program without addressing or resolving its multiple serious inadequacies, close quote. Ms. Curran, this strikes me as conveying that contention 2 is challenging Diablo Canyon's CLB and therefore would be outside the scope of the proceeding. How is it not challenging the CLB and therefore outside the scope of this proceeding?
Judge Mercer, this contention is something like the contention that the licensing board admitted in the Indian Point case that we cited. And in that case, there were pre-existing problems that were not resolved, weren't addressed in the aging management program. And so the aging management program was just perpetuating these problems and not dealing, very significant problems that if they're disregarded, then your aging management plan doesn't really make sure that this very important passive safety component is going to be adequately monitored and managed. And in section 4 of his declaration, Dr. McDonald goes through a number of statements in the license renewal application where PG&E demonstrates its reliance on the existing program as a basis for going forward and saying, well, we're going to do some additional things, but we rely on calculations that we made to date, testing that we've done to date. And we as Dr. McDonald sets forth, the last time the pressure vessel was sampled, the samples were taken from the pressure vessel and tested was 2002. That's almost 25 years ago now. And the last time that the ultrasound testing was done on the pressure vessel was 2005. They're supposed to happen every 10 years, and that was delayed. NRC approved an extension of time until, I think, 2025. So basically, PG&E is going into this aging management plan without a really good sense of what is the condition of the pressure vessel and what is needed.
Well, and I'm going to give PG&E and the staff an opportunity to respond to the question I just posed to you. But before we get there, because you've led into Dr. McDonald's report, I wanted to follow up with that, because setting aside whether you can just incorporate by reference Dr. McDonald's report without pulling it in, calling it out specifically in the petition, I looked at Dr. McDonald's report and I saw only 5 pages from the license renewal application that he cited in his 2024 report. Of course, there were none cited in the 2023 report because that was done before the license renewal application. But I only saw 5 pages. And on those 5 pages, I saw only 2 things that he challenged or could potentially be deemed to be a challenge of the license renewal application. One being the timing of the removal and testing for capsule B, and 2 being an issue about the ultrasonic testing of the beltline welds and how that relates to the scheduled ultrasonic testing inspection. But as it relates to the specificity issue here, one, the issue of the testing of capsule B, Dr. McDonald answers his own question later on when he cites to the correspondence between PG&E and the staff that PG&E is going to pull the thing for testing no later than 2025. So there is a commitment to pull and test. And the whole issue of the ultrasonic testing of beltline welds, he brings up the fact that those 2 things aren't married together, but then never mentions or explains why or how they should be considered together. So I'm not seeing anything in those 5 pages where there's really any specific explanation or delineation of what the dispute is with the license renewal application. Are you able to help me with that?
Well, I'll start with paragraph 19, which is the first paragraph in section 5 on page 6. Let me just back up a minute and say that the purpose of section 4 is to lay out the sections of the license renewal application that rely on the existing surveillance system and the conclusions PG&E reached from it in the license renewal application. And, you know, there's 1, 2, 3, 4, 5, 6 or 7 paragraphs there where he gives examples of statements in the license renewal application for, and I can go through those in detail, but...
Well, 1 second there. He does call out in each of those paragraphs a part of the license renewal application, but he doesn't necessarily say something's wrong. Like in paragraph 13, all he does is quote page 4.2-2 and doesn't explain what's wrong with or why that's being called out. Similarly, in paragraph 14, he does the same thing, but then he provides a paragraph that says, thus the previous schedule for withdrawal of capsule B is relied upon by PG&E for its plans. However, I am unable to locate any commitment by PG&E to a deadline for removing and testing capsule B. So I see there he said, this is the paragraph I'm citing to, this is the problem, which he didn't do the prior paragraph. But in this particular situation, or this particular instance, the very paragraph 19 and paragraph 20, he specifically cites to the correspondence between PG&E and the staff where there is a commitment by PG&E to remove and test that. So I'm trying to figure out what parts of the license renewal application is he challenging and what the particular challenge is, because yes, he's called out pages throughout his report, but he hasn't then identified and said, and this part that I've just quoted is wrong because, or is deficient because, or does this incorrectly. That's the part that I'm missing.
Well, I think that in paragraph 14 of Dr. McDonald's declaration, where he says, I am unable to locate any commitment by PG&E to a deadline for removing and testing capsule B. There is no deadline in the license renewal application for testing capsule B. And therefore, we're relying on statements made by PG&E in the current license term, the initial license term, which have changed over time. They've gotten, I don't know how many extensions of time. This capsule was supposed to be removed in 2009, and they've gotten multiple extensions. Right about when PG&E was decided to close Unit 1, it was in 2022. PG&E didn't take it out in 22. I don't think they even wrote to the NRC about it. Then they got another extension until I guess they got one until 2023, and then they said they couldn't get it out, and the NRC said, you know, do it in 2025 or as soon as you can do it. That's in the current license renewal term. And then in comparison to that, we have no commitment for the renewal term. It's just this series of extensions in the current term going into 2025, which could be in the current license term because of the exemption that the NRC issued to the timely renewal rule. The current license could go on past 2024 under an exemption issued by the NRC. So it's in no man's land.
Do petitioners cite anywhere something that says in the license renewal application there has to be a specific date by which this testing is to be accomplished? Or
We rely on Dr. McDonald's expert opinion that it has been far too long since PG&E took any kind of sample from the Unit 1 pressure vessel and tested it to determine its condition. In the meantime, PG&E has been relying on data from another reactor when it was required to have tested it in 2009.
Well, I don't want to get into the substance because that's not the role of the board at this point in time. But, I mean, the staff did respond to the 2206 petition and specifically provided information that directly contradicts that information that you're giving us now, that the staff has said that all of the regulatory requirements for testing had been accomplished. At least as I read the 2206 response, the staff or PGE can chime in when it's their time if I'm incorrect. But again, I come back to that may be Dr. McDonald's opinion, and no disrespect meant to Dr. McDonald at all, but for us, we have to be able to say there's some requirement that this testing has to be done, and the failure of the LRA to include a deadline is deficient, and therefore this is either a sufficiency contention or a contention of omission because they don't have that date, and we have to be able to point to that. Because as Judge Dracoris mentioned, as it relates to contention 1, our decision can go up for appeal, and we've got to be able to explain to the commission why we're saying what we're saying. And we can't justify a deficiency in the LRA based on Dr. McDonald's opinion that's not tied to any type of regulatory requirement. So that's what I'm missing is the hook to the regulatory requirement where something is wrong.
It was initially initial licensing period.
Judge Mercer, two things. One is that there are no license renewal requirements in Part 54 for testing of capsules. The requirements, and in the regulatory guidance, it pertains to the initial license term. Capsule B, the capsule that is now planned to be taken out in 2025, was installed in the initial license term and was expected to be taken out in the initial license term. We actually have a case pending in the Ninth Circuit arguing that the NRC amended the license when it allowed the recapture of the the time for low power testing on the condition that capsule B would be taken out in 2009. But once that was missed, once that time for taking out the capsule B during the initial time license term, once that's missed, there's no regulatory requirements. This is a great gap in the NRC's oversight of pressure vessels, and that's why we are now in the realm of looking at expert opinion as to what would be reasonably required in order to assure that this pressure vessel, which had problems from the moment it was purchased, that it remains maintains integrity through the 20-year license renewal term. This falls to a great extent on the expert opinion on analyses that have been done up to now by Westinghouse, and on the results, PG&E is relying on the results of capsules that were taken out earlier, capsules S, Y, and V, and now extrapolating what's needed in the license renewal term. That is the environment that we are in here.
Okay. Mr. Leidy, I'll turn it over to you for PG&E's position relative to the couple questions that I've posed, and I apologize that you're getting several questions thrown at you at once, but if you could address those from PG&E's perspective, please.
Thank you, Your Honor. Yes, I'll try to address those in turn. I think, Judge Mercer, you were right on point in noting that even though the petitioners wish to argue that there's no deadline in the LRA for testing capsule B, that's because there is no requirement for that information to be included in a license renewal application. The petitioners point to no requirement. There isn't one, so that's not a genuine dispute on a material issue of law or fact in this proceeding. I think, to summarize my understanding of the petitioner's position, it's that they assert it is a defect for the aging management program to rely on information from materials that were monitored within the scope of the CLB materials surveillance program. But they don't explain why that is a material defect either. In fact, if you look at the Gall report, the aging management program that is the template approved by the Commission and approved to fully satisfy the requirements of Part 54 for aging management on reactor vessel surveillance, it has an AMP for that purpose. It's Roman numeral 11.M31. And if you look at item number 1, scope of program, it specifically says, materials originally monitored within the scope of the licensee's existing 10 CFR Part 50 Appendix H materials surveillance program will continue to serve as the basis for the reactor vessel surveillance aging management program. It's explicitly endorsed by the Commission. It's expected that this information would be part of the AMP. So for the petitioners to rest their entire contention on just the assertion that it relies on CLB information, I think it's pretty clearly immaterial, and they haven't raised a genuine dispute here. I think one other thing that I would note is that Ms. Curran mentioned the Indian Point case earlier. That's a case that was cited in their reply brief, LBP-08-13, for the proposition that embrittlement issues are within the scope of a license renewal proceeding. I would just note that that decision pertains to a contention of omission where the applicant did not include an AMP for reactor vessel aging management. The applicant later supplied one, and it superseded that contention, but that was what was being discussed there, the absence altogether of an AMP. Here, what we have is an AMP that exists but hasn't been challenged with any specificity. One other point that I would note is that even though there is no hard deadline for testing capsule B, The Appendix H requirements impose limits on operation if a capsule that can't show extended operation has been pulled. And if you look once again at the Gull report, the template aging management program for reactor vessel surveillance, it explains exactly what happens in that circumstance if you don't have a capsule that can show that you can continue operating. It says, quote, operating restrictions are to be established to ensure the plant is operated under the conditions to which the surveillance capsules were exposed. So the program itself deals with that issue. And once again, petitioners haven't engaged with that information. They haven't disputed that information. This is a commission-endorsed aging management program that PG&E has adopted, and the commission has generically determined that it meets the requirements of 10 CFR section 54.21. So all along, PG&E has followed the requirements for capsule removal, has requested appropriate staff approvals for changes to schedules where required. That has been reviewed yet again in the 2206 petition process. And throughout all of this, the petitioners haven't identified any genuine material dispute here in the license renewal application on this issue.
All right. Mr. Wahaka, before I get to you, I want to go back to Ms. Kern and a question I should have asked. The AMP that's being challenged, it is the RPV surveillance AMP, is that correct?
Yes.
Okay. All right. Mr. Wahaka, if you'd like to present the staff's position on the couple questions that I addressed to Ms. Kern at the beginning, and then we'll circle back to you, Ms. Kern, for follow-up on that.
Yes, Your Honor. One additional thing that the staff would stress is that, I think you mentioned it, but to get into it, is that for the contingent admissibility standards in the regulations at 2309 F1, the requirements for all of these criteria, including genuine dispute, which we're discussing now, are, quote, for each contention, the request or petition must, end quote, discuss those things. And in this case, contention 2 makes 0 references to the license renewal application. So that does not meet the genuine dispute requirement, which requires references. And instead, it points to 2 declarations. However, as we showed in our pleading, there's case law that says that that is insufficient. And then even if we were to get to the point where these disputes, certain portions are being referred to, after the declarations identify those things, then it just returns to the previous arguments that were made in 2023 for why the plant is currently unsafe. And that belies the fact that these arguments actually have to do with those referenced portions of the license renewal application. And regardless, those exact arguments were referred to the staff under the 2206 process by the commission, which, as the staff's position is, that is the appropriate process for these because they are challenges to the current licensing basis. And that process involves such things as asking the sponsor of the 2206 petition for additional information. So in this case, the newer declaration has a few additional comments and arguments, and the appropriate place to bring those was in the 2206 process. And as you referred to, Judge Mercer, the staff has put together an initial assessment. The initial assessment goes through every argument that's made here and has a written record of the staff's position on it. And so to have a hearing in this forum on the same issues would just be duplicative. And that, again, just illustrates the point that we are out of scope here discussing these issues in this licensing proceeding.
Ms. Kern, would you care to respond to information presented by both counsel?
Well, listening to Mr. Leidy read the section from the Gall report, I may have misheard him, but it sounded to me like what the Gall report was saying was that the material monitoring that is in the original license term is used as a basis for the aging management plan. And it only makes sense that this is a a single component. It can't be replaced, or not without spending a huge amount of money. It's very difficult to repair. So it's really important to have some continuity over time between this monitoring program that was clearly required during the first 40 years, and then this aging management plan that, for which the only thing that Mr. Leidy can cite is staff guidance. There's not regulations for what to do with a pressure vessel during the license renewal term. So if it's really correct that the monitoring of the materials in the pressure vessel up until the point of renewal is important, it's something that is built upon in the aging management plan, then if there's problems with that current program, it's highly relevant to whether the aging management plan is going to be successful. Otherwise, it's just like rearranging the deck chairs on the Titanic. You have to have a sense that the foundation that you're building on is adequate, because that is what the aging management plan does.
But with that being the issue, though, Ms. Curran, how do we get around the fact that what you're challenging then is the current licensing basis for the plant?
The way we address that is to say that the aging management plan is inadequate because it does not address serious concerns that the reactor may be unduly embrittled. For instance, it doesn't include a requirement to actually test capsule B right away. It's not in the license renewal application. It doesn't include ultrasound testing.
But where is the requirement that those be in that aging management plan?
What we are relying on is Dr. McDonald's expert opinion that those things have been delayed unduly and unsafely, such that we are now entering the point of licensing renewal, the time of license renewal, not having a good idea what is needed, because we don't have a good idea of what the condition of this reactor vessel is. You can't have an aging management plan that for a reactor vessel where you don't have a good idea of what is the situation you're dealing with.
But Doctor, in that answer, as I understand it, Dr. McDonald then is challenging the current licensing basis, saying the current licensing basis is insufficient to give us that baseline, which circles back to my question of how is this not a challenge then to the current licensing basis? Because
the aging management plan itself assumes that this pressure vessel has been adequately cared for and inspected throughout the past 40 years. If the aging management plan assumes that, then it becomes relevant to the past 40 years becomes relevant to the aging management plan. We are not attacking the CLB by itself. We are attacking the fact that this aging management plan is supposed to be based on a reasonable amount of information about the condition of the pressure vessel, and they don't have it.
Sure.
In Dr. McDonald's declaration, I believe it's paragraph 17, he references page B295 of the LRA. And in page B295 of the LRA, it's dealing with section B2318, which is the reactor vessel surveillance program, which is what we're talking about now. It says that the reactor vessel surveillance AMP is an existing AMP, and I believe that it is the AMP that we're talking about as being described as the current licensing basis, or within the current licensing basis. Is that correct? And I asked that question also to Mr. Leidy.
Exactly. the same.
I believe that they are slightly different programs. So the first sentence in B2 318 talks about the existing AMP, but this AMP then includes, that's part of the LRA and would be for the period of extended operation, includes the additional information that is here in the document, consistent with the license renewal AMP from the Gall report. So I think it's a bit different.
That's a question.
Well, no, that's, let me leave the Gall report out of this, and then we'll come right to it. The way it appears, the AMP, and I don't think this is uncommon in license renewal, where existing AMPs, existing programs are just simply moved into the LRA. And that seems to be the case here. So the attack on the, to me, it's the logic that says if, you know, A equals B and C equals B, then A equals, if A equals B and C equals B, then A equals C, okay? And logically equals B. So if the AMP that we now call the current licensing basis is the same AMP that is in the LRA, and if one is attacking the current licensing basis AMP, is one then not actually attacking the licensing renewal application AMP? I'm trying to make that separation. That you're making a separation between those two things, and I'm trying to see that separation.
My understanding is that there's a slight difference between the existing AMP and the one that will be used for license renewal, but I do need to get confirmation on that from a
It doesn't say that in any documentation that I've seen. I may have missed it so much, but I guess I'll ask that question to Mr. Wahetka.
Your Honor, the NRC staff hasn't completed its review of the license renewal application yet, so the staff doesn't know that one. But the staff's position is that to have a genuine dispute, petitioners have to explain why the AMP is wrong, but instead of explaining why the program to manage aging is wrong, they continually look backwards at things they think that the PG&E should have done instead of what it did. And it said that in the past, PG&E should have removed and tested more surveillance capsules, or that in the past it should have made more ultrasound inspections of wells, and in the past it should have performed analyses differently. But again, as we had discussed with the initial assessment of the 2206 petition, all of these arguments about things that happened in the past are all consistent with the NRC's rules, and to the extent those rules incorporate by reference industry guidance documents, and so there's no basis here for an admissible contention.
Well, we would say the past is prologue, and what's sauce for the goose is sauce for the gander. PG&E is relying on the existing surveillance program and on the results of it in order to say they're going into the license renewal with a period with a reactor vessel that is has integrity and then only needs some additional monitoring for the next 20 years. And they've done fluence calculations to show that things are going to be okay for the next 20 years. And we're saying that it's not just the fact that they missed deadlines for testing the surveillance capsules, it's that they don't have good data on the condition of the Unit 1 pressure vessel. They just don't have it. So to have an aging management plan where you say, you know, they have to be able to build it on some sense that they're managing something that is not going to go downhill very quickly. In the license renewal term, they're supposed to show how aging can be managed safely over a 20-year period. And they don't have anything in particular to show how they would be dealing with a seriously embrittled pressure vessel, which is what Dr. McDonald thinks they have.
Yeah, that I understand, but the problem we're having is the distinction between the program in the LRA and the program that's in the CLB. And Dr. McDonald has basically attacked, criticized, if you will, the program that's in the CLB. The question is that also the program that is in the AMP? Sounds like it is. And however, there was no, other than a few small sites, there wasn't any direct reference to the AMP that's in the LRA, which is a problem. And the other problem is, I believe, that the ANP, that once you move the CLB program to the AMP, even if it's the same program, it's been declared to meet the GAL report requirements. And if it meets the GAL report requirements, then it cannot be criticized within the guidelines as we have them, or at least the rules that have been defined for contention and admissibility in that regard.
Well, we would disagree with that, Judge Tokoros, that
Good.
the determination that a program is consistent with the GAL report is something that is a legitimate subject of challenge and a contention.
I'd like Mr. Lightly to address that.
It is a legitimate subject of challenge and a contention, but unfortunately for the petitioners, they didn't raise that challenge. There is not one word in the petition or in the McDonald Declaration that suggests that PG&E's AMP is not consistent with the GAL report. That's one of the many deficiencies in the petition, in the contention, that the petitioners just haven't addressed. They don't address the Part 54.21 requirements. Which one allegedly isn't satisfied here? Why isn't it satisfied here? Why isn't an AMP that's consistent with the GAL report enough to satisfy those requirements? How is PG&E's program allegedly different from the GAL report? None of that is addressed in the contention. So we have multiple overlapping deficiencies here.
And
Yes.
before you answer, I actually had a question along these lines. I didn't see anywhere in the petition where petitioners challenged whether the reactor vessel, I'll get this right. Reactor vessel surveillance program, whether that is compliant with the GAL report, or anywhere that the petitioners challenged that that AMP was not explained in sufficient detail or didn't have enough information in order to determine if it was sufficient or consistent with the GAL report. Did we miss that? Is that somewhere in there?
I think we did not bring up the GAL report. I was responding to something that Judge Takoro said that we disagree with. It was a theoretical thing about what's the significance of the GAL report. The GAL report is a guidance document. It's not a regulation. We did not address the GAL report. We relied on Dr. McDonald's expert opinion regarding representations that are made in the license renewal application that the current monitoring program forms a basis for the AMP. So as long as PG&E brings that issue into the license renewal application, as long as they say, well, there's some part of the CLB that forms a foundation for this AMP, then it's legitimate for us to challenge whether the information that they're relying on from this program that's been conducted under the CLB over all these years is a good enough starting place for their AMP, because that's the foundation. If we want to go after the house, we get to do the foundation too, not just the wood on top.
The other complication, I think, here is, well, let me make one statement. My understanding is that in NRC 1801, it is identified that if an applicant utilizes the AMP that's in the new reg, that is considered an acceptable AMP. And I shouldn't have said that you can't criticize it, but that is the position that the commission has taken on that, I believe.
Judge Chakoros, I would just amend that a little bit to say that is the staff's guidance. And the staff is a party, it's not a regulation. So we can come in and say, we have concerns that are not addressed by simply saying this AMP is, it's consistent with what's in Newark 1801.
All right, well, so let me get back to the other complication, and that is that currently, Dr. McDonald's declaration criticisms are being considered under the 2.206 umbrella, which is the CLB umbrella. But at the same time, there is documentation, as I quoted, that indicates that the CLB and the AMP and the LRA are the same thing. So, that's what we're looking for a resolution on right now.
Well, if they are the same thing, then that's unequivocal that our contention is admissible. And as far as the 2206 proceeding, the fact that we brought an enforcement proceeding relating to the current operation of the plant is irrelevant to the admissibility of our contention here. And just remember, too, that our enforcement petition, initially we brought it to the NRC Commission, and the Commission referred it to the staff. The staff are the same people who we think were not doing a good enough job of supervising the surveillance program and giving extensions willy-nilly for the removal of Capsule B. So those are just the same people whose actions we disagree with. It doesn't say anything about this license renewal proceeding.
Mr. Leidy, are you preparing to answer that?
Sure. There's a couple of things to respond to there, I think. First of all, the Gall report does note that AMPs consistent with the Gall report are considered acceptable, but that's not just a staff determination. The Commission has explicitly said that in its orders, and those orders are cited in our brief in section Roman numeral 4, Charlie 1. So it's more than just guidance. It's explicitly endorsed by the Commission for these purposes. But I think the broader issue, something, even if we just want to step away from the CLB for a minute and explain another reason that these arguments are out of scope. Let's just say that it was okay for Dr. McDonald to challenge this AMP as a proxy for the license renewal AMP. Those challenges are to the NRC's regulations. Those challenges are to the NRC's guidance. Those are not challenges to the application. There isn't an allegation that PG&E hasn't followed the rules here. It certainly has. That's been confirmed over and over. It's confirmed in the petition review board proceedings. It's confirmed in the many schedule adjustments and approvals that PG&E has received. Dr. McDonald is simply advocating for an entirely different regulatory regime. That also is not within the scope of an individual adjudicatory proceeding. So setting aside, regardless of how we come out on the CLB issue, there's a separate independent scope problem here because the attacks are to the NRC established and codified process for analyzing embrittlement, the process that PG&E has faithfully followed and fully complied with all along. And there are no allegations in Dr. McDonald's report otherwise.
Your Honor, as you were discussing about the CLB and then the AMP, well, the CLB is right now, and that is the withdrawal and testing of the previous capsules, and that is everything that is the subject of the challenges here, everything that was done in the past. The AMP relies on the withdrawal and testing of capsule B, and that's the future, and that AMP is explaining why withdrawing that capsule will provide reasonable assurance that the plant will continue to operate consistent with its current licensing basis over the period of extended operations. So in this case, to have a genuine dispute that's within scope, what the petitioners had to do is they had to attack that AMP and attack why its plans to withdraw and test capsule B would be inadequate. But here, all they're doing is they're pointing back to their old arguments about why withdrawing the previous capsules was inadequate, why not doing more testings was inadequate. So that's the line between current licensing basis and the issues unique to aging management. And we don't think they've crossed that line to the aging management side.
All right, thank you.
As far as we know, there's no commitment. First of all, I think Mr. Leidy is in agreement with us that there is no regulatory requirement for withdrawal of capsules during the license renewal term. So it's, and PG&E has said in this license renewal term that it's going to try to withdraw another capsule in 2025. And the NRC has said, well, we hope you can do it. And we don't see it. I think Dr. McDonald says in his declaration, I do not see a firm commitment in the license renewal application to withdraw capsule B. And so that is an issue. It's the can that's been kicked down the road, and it's not a commitment in the license renewal application.
Is there some requirement that it be a commitment in the license renewal?
There's not, Judge Arnold, and that is the problem here. There was a requirement in the initial license term, and the NRC issued extension after extension until it finally got to a year past the expiration date, 2025. Those extensions were issued in the initial license renewal term. And now we have a license renewal application that vaguely refers to it but doesn't make a commitment. So something that was supposed to happen in the initial license renewal term never happened, has now gone off in the ether. And that's an issue. That's a really serious issue because 2002 was the last time that a capsule was taken out of Unit 1.
I just want to circle back on the Gall report.
tell what
I had asked Ms. Curran a question. I want to make sure I get an answer. Is there anywhere in the petition that the petitioners have challenged whether this AMP, the surveillance AMP, is consistent with the Gall report, or that there is insufficient detail or information to determine whether it is sufficient or consistent with the Gall report?
We do not address the Gall report.
Okay. And do not address consistency therewith either?
That's right.
Okay. Now, I wanted to address an issue in contention 2 to see if it is an issue. In the statement of the contention on page 16, there's a reference to time-limited aging analysis being inadequate. We've been talking about contention 2, and we've all been talking about an AMP as opposed to TLAA. I just wanted to make sure, is there a TLAA argument being advanced by petitioners here? Because if so, what is it, as I didn't see it, other than in the statement of the contention?
Excuse me, I'm just looking over the contention.
Sure.
Okay, in paragraph 11 of Dr. McDonald's declaration, he talks about TLAAs.
Yes, he mentioned TLAA as a, let's see, once to define the term and twice citing from the license renewal application's use of the term, but I was not able to find any challenge to a TLAA in the petition or in his report. I saw the words, but I didn't see any type of a challenge, and I'm trying to figure out, is there a TLAA aspect to this contention?
He says in the last sentence of that paragraph, thus TLAAs depend significantly on the calculations and analyses developed in the initial license renewal term. So he is making a general claim about TLAAs that are, you know, essential elements of an AMP, that they go back to the calculations and analyses that were done in the initial license term. So that is the connection.
Well, what TLAA? I don't...
He's not specific. He's saying that this is a general problem.
So then how do you get around the specificity element for that? I mean, how does PG&E know what they're supposed to respond to, or the staff, if he's just challenging TLAAs in general?
But he cites, for instance, in paragraph 13, he quotes the license renewal application embrittlement analyses.
I believe the TLA that is being discussed is associated with pressurized thermal shock calculation and two other calculations, which I don't remember at this second. That's the TLAA that's being discussed. The existing TLAA is, my understanding is, the existing TLAA that calculates PTS and these other items regarding embrittlement is moved forward into the LRA. The calculations for PTS and other important embrittlement calculations that are being done today are also going to be done identically in the future in the LRA. That's my understanding. If that's not correct, someone correct me on that.
So yes, and he's just saying that these are a set of TLAAs that relate to pressure vessel embrittlement and that rely on the existing information that's been developed over the initial license renewal term. That's what he's citing. That's what he's concerned about.
But I
It's not a challenge to the TLAA.
I'm not seeing anywhere where he's calling out specifically, there's something wrong with this TLAA. He may say it's based upon calculations that have been done over the original licensing period, but I don't see anywhere where he has come out and said, and this information is incorrect, and because of that, XYZ, or this TLAA is wrong because they screwed up this and such during the initial operating period. He mentions TLAAs, and he cites to PG&E's citation to TLAAs, but I don't see anywhere where he comes out and says, and the TLAA was supposed to do this, but it didn't, or was supposed to encompass these things, and it didn't include that. That's what I'm looking for.
Challenging what PG&E says in the license renewal application about the TLAAs. So for instance, in paragraph 13, when he's talking, he
It's paragraph
quotes
13.
page 4.2-2
That's correct.
of the license renewal application that says the current license period reactor vessel embrittlement analyses that evaluate reduction of fracture toughness of the DCPP units 1 and 2 reactor vessel belt line materials are based on predicted 40-year EOLE fluence values. And
Right.
then skip down to the end of that paragraph.
Right, I can read the paragraph, but my concern is the paragraph is just plopped on the page. There's no analysis, there's no conclusion that I can find by Dr. McDonald that says, and this part from this LRAA is deficient because, or
Well, yeah,
this is
okay.
wrong because. I don't see that anywhere.
Well, then
in
let me
the-
just say again, that the crux of Dr. McDonald's analysis is that throughout the license renewal application, you find statements by PG&E saying our aging management program, our TLAAs, are based on our existing surveillance program. This is an example. And then he says in paragraph 19, this is inadequate because you do not have an adequate existing surveillance program on which to base these representations. That's the specificity. He's quite specific about the sections of the license renewal application that make these representations. We are relying on the existing program for fluence calculations, for estimates of the degree of embrittlement, for how soon do we have to test again. That's what they're relying on, what they claim to have done in the initial license term. And Dr. McDonald is saying that is not adequate because they have not done an adequate job up till now.
Counsel for PG&E and counsel for the staff, would you care to weigh in on the TLAA issue?
Thank you, Your Honor. I think you're exactly right. I don't see any specific engagement with a TLAA, an explanation of which part of Part 54 isn't satisfied, allegedly. The reason for that alleged non-satisfaction, other than the vague assertion that, well, you looked at information from your CLB that I disagree with. That's a challenge to CLB information and not a challenge to anything in the LRA itself. And I think that's an important distinction, not just on TLAA, but going back to the AMP. I do understand that the current RV AMP is essentially the same as the proposed license renewal AMP for the reactor vessel. But the difference, again, is that what Dr. McDonald appears to be challenging is the calculations and analyses, the information that came out of the original operating term. That challenge is to CLB information, even if the text of the AMPs are the same. There's no challenge to the text of the AMPs. It's to the calculations and analyses performed consistent with the NRC's regulations that Dr. McDonald simply disagrees with. And so I think that flows through both the AMP and the TLAA issue. And the TLAA issue is further so vague as to be incapable of really responding to it because I don't know what the challenge is.
Mr. Oaxaca?
Your Honor, the NRC staff just understands from this whole discussion that there's no challenge to the license renewal application. Current licensing basis arguments that were brought previously to shut down the plant are being repeated. Those arguments were sent to the 2206 process. The 2206 process is explaining why all those events in the past were the way that they were. And going forward is the AMP, which is based on the GAL, and the GAL report says that an acceptable AMP is one that pulls a capsule that will have fluence that's 1 to 2 times the fluence at the end of life, which would be the 60-year period, and that is pulled before the end of the 60-year period. So that's what the license renewal application actually discusses, but that discussion is not challenged by the petitioners here.
Go ahead.
Dr. McDonald declaration points to a page in the LRA, I believe it's page 491, I believe, which talks about the TLAA that we're discussing. The TLA that we're discussing calculates, and it is now written in front of me, so I don't have to remember it, neutron fluence, the pressurized thermal shock upper shelf energy, the adjusted reference temperature, and the pressure temperature limits, and that includes low temperature, high pressure analysis, LTOP, I think we
Low
used to
temperature
call it.
overpressure.
So he's then indicating in paragraph 19 that was quoted to us some of the problems that he has with that analysis, those analyses. Right, and now to my understanding, that's it. I don't know. Oh, I'm sorry. There's one other thing. There's additional analysis that is discussed in the 2.206 document in September of 23, and the current declaration by Dr. McDonald points to that, and says go look over there if you want to find out more about this. To my understanding, that is sort of the totality of the TLAA situation that's being criticized. Whether it's adequate or not is the big question, of course.
Right, and the staff would reiterate that all of this is in the declaration that we're talking about here, whereas, as we stated, the regulations require that this challenge be made in the hearing request, in the contention itself, and there's not a single reference in the hearing request.
Yeah, I think there's no dispute by anybody on that.
Yeah. Question along the same lines. I mean, 10 CFR 2.309 F1 gives the contention admissibility requirements, and it says that these must be supplied by the petition. And I'm looking at your petition, and where I expect to see these things specified, it says it's in the attachment. Now, Ms. Curran identified the reactor pressure vessel AMP as the AMP that was the subject of this, and it is in fact discussed in Dr. McDonald's statement, page 6, paragraph 17. But at the same time, on page 5, paragraph 16, Dr. McDonald discusses the aging management plan for vessel internals, not for the reactor vessel walls. So it's left to us to figure out what's being challenged. The same thing occurs for the time limiting aging analysis. Now, I want to ask a question, we'll go around. Is this a problem in the specification of your contention? It seems to be for me. But.
We thought that there would be no purpose served by simply pasting Dr. McDonald's declaration into the contention. And it was quite specific about the sections that he is criticizing. And so therefore, that was how we met the requirement.
Mr. Lighty?
It's certainly a problem according to binding commission precedent. This approach is insufficient for contention admissibility, and I think it's for the very reason that we're seeing here today. It's just not exactly clear what's being argued. We're sitting here trying to figure out what the contention is. That was a pleading burden, and it's unmet here.
And staff?
The staff agrees that there's no genuine dispute here, Your Honor.
Any other questions on contention 2?
Oh, no. Yeah, I do.
Okay.
Okay, okay, I'll address this to Mr. Curran. Paragraph 19B on page 7 of his declaration, Dr. McDonald finds puzzling the staff's approval of PG&E's disregard of a piece of data. I'm wondering exactly what you're meaning there. Is he finding that it's against some regulation or guidance, or I'm not sure what the purpose of his puzzlement is in this contention.
Credibility.
PG&E disregarded data in 2002 that they said they found at the time were not credible. And Dr. McDonald goes into extensive detail about that in the declaration that is attached to this one, but he summarized it in this one. So I think he refers to section 5A of his attached declaration. So we didn't repeat everything in the other declaration. It seemed more efficient to refer the reader to that. But his point here is that there is data that are relied on in the aging management plan or there's data that are not relied on that should have been considered credible and that showed embrittlement issues with Unit 1.
Okay. Being an engineer, there's never enough data. But the staff approved this, and did they do so disregarding some guidance?
Yes.
Okay. And that's in
That's
the
in
second.
much more detail in Dr. McDonald's the declaration that is attached to this one, which is dated September 14th, 2023.
Okay. On page 7, paragraph 19C, Dr. McDonald states PG&E's reliance on substitute data from other reactors was also unreasonable. Is using embrittlement data from other sister vessels an unusual practice?
No, it's sanctioned by NRC.
It is sanctioned by NRC,
But they have to be sister plants.
but they need to be sister plants. There needs to be some basis for comparing them. And Dr. McDonald believes that there was not sufficient basis for using this data from the Palisades plant.
That's in 5061A. Correct, I believe.
On page 17 of the petition, you reference the erroneous assumption that embrittlement accrues in a non-Markovian manner. Is there any regulation or guidance that says this assumption was improper?
This is based on Dr. McDonald's expert opinion.
Okay. Did the assumption that PG&E make, was it an uncommon assumption, or are many plants assuming unreasonably?
Well, it's well recognized scientifically, but it hasn't made it into any regulations. What happened? On the business is that the system has memory what went before. So you have a system where the power is going up and down. Memory is different than if the power is constant. So it's basic. It's a very complex scientific issue. It's basics of the contention.
My understanding is that it's a complex issue and that it hasn't made its way into regulations. It's a concept that
The system has memory
the system has a memory
of what goes on before.
of what went on before.
Thank you. Now I'm going to ask PG&E essentially some of the same questions. You used data from another plant saying it was a reasonable surrogate for your unit. Did you follow the guidance available in selecting that plant?
Yes, Your Honor. Actually, use of sister plant data is required by the regulations, and there is NRC guidance that explains how to translate that information. And so PG&E fully followed that process.
Would you happen to know where in the regulations that requirement is?
I do not. I will get that and let you know. As to the issue of discounting not credible data, I do want to note that that data was not disregarded. It's a very different thing, right? Determining that data is not credible is through a scientific process. That process is outlined in Regulatory Guide 1.99, and that is the process that PG&E followed.
And the use of the non-Markovian embrittlement, do you know of, is that common within the industry? That is your modeling inconsistent with other plants?
No. It is consistent with NRC requirements.
With requirements.
And guidance.
Just one other thing. The removal of samples and testing. Now, I know typically when you remove it, the fluence the sample has received is greater than the fluence for the average vessel, so that you're looking at some future operation. Now, the last sample you removed that you considered to be good data, the fluence it received was characteristic of what time in that vessel life?
So it went through the entire initial operating period of 40 years. And so that's why Capsule B was not withdrawn, because it was not required for the initial operation.
It was inserted when capsule B and Y was extracted.
Do you have a comment?
We would just disagree that withdrawal of capsule B was not required for the initial license renewal term. And that's discussed in Dr. McDonald's September 2003 expert report. This is a capsule that was put in as part of the initial surveillance program. It was approved as in the initial operating license term, and it was only after PG&E decided to apply for license renewal that the NRC and PG&E started to talk about it as if it was related to license renewal and could be postponed indefinitely.
That sample is going to be removed in 2025?
Well, that's there's been several attempts to remove it that were unsuccessful. The latest request for an extension said, we will try, and the NRC said, okay, to try. And that's all there is. There's no, this is the end, this is the ultimate deadline. The can just keeps going down the road.
Question for staff. Will there come a time where you will tell PG&E that sample needs to be tested, or is this something that could be in there forever?
Your Honor, this isn't something that the licensee just has to try. The current withdrawal schedule that's approved by the staff says that this capsule has to be removed in either fall of 2023 or spring of 2025. This isn't something, the 2025 didn't happen later. That was always what the schedule change stated. And then the AMP that we would approve as part of approving a license renewal application, that is what would solidify this. And then the AMP, if it's consistent with the Gall report, says that before the end of the period of extended operation, a capsule has to be withdrawn that has 1 to 2 times the fluence at end of life. And so that's the requirement from the Gall, and the Gall is something that the commission has said, if you meet the Gall, then you meet our regulations.
So PG&E doesn't have to make a commitment to remove it since there's a requirement to remove it.
Yes, they'd be required by their aging management program that would be approved as part of the license renewal application approval.
Okay. I'm out of questions on that.
Any other questions on contention 2? All right, before we move on to contention 3, I will throw open to council if you briefly, and I emphasize briefly, have any additional comments on contention 2 that you think need to be brought to our attention now versus in the final argument. You now have the ability to do that. Ms. Curran?
I'm sorry that I don't have a copy with me of the letter that the NRC wrote to PG&E allowing the most recent extension of time for removal of the capsule B. But my clear recollection is there's no hard and fast deadline, and that there's wiggle room if there's still problems. I could be wrong. I'd be very happy to send the letter to the licensing board to complete the record as to where things stand with capsule B. But my recollection is there's no firm deadline for removing capsule B. There's no firm deadline for removing capsule B in the license renewal application.
Your Honor, I could give you the ML number for that letter. It's ML 23199A312. 199A312.
Thank you.
Okay, and that letter specifies it will be withdrawn?
2023 or 2025, yes, Your Honor.
Mr. Leidy? Anything final?
Yes, just briefly on the regulation regarding determination of credibility and use of sister plant data is 10 CFR section 50.61. And I would just sum up here that the criticisms that we're hearing today are all about processes that have already occurred, CLB information. And the basis for those criticisms is a disagreement with the NRC's regulations and guidance. And so we have, in addition to the lack of a genuine dispute in the petition or in the declaration, the basis of the alleged disagreement is simply outside the scope of this proceeding on multiple levels.
Mr. Wahodka?
Your Honor, the NRC staff's position is that the record reflects that contention number 2 does not meet the contention admissibility requirements for genuine dispute or for scope. It has to do with the current licensing basis issue, and it is properly in the 2206 petition process before the staff where the commission put it, and there's nothing further for the board to rule on these matters.
Thank you, counsel. Turning now to contention 3, Coastal Zone Management Act. we read contention 3 as claiming that PG&E has not demonstrated compliance with the Coastal Zone Management Act, or CZMA, because it did not include with the license renewal application a Coastal Zone Management Act concurrence from the California Coastal Commission. Is that a correct reading of the contention, Ms. Curran?
Yes.
Now, before we proceed further, as formulated in the petition, petitioners were challenging commission regulations, specifically 10 CFR 5145 B, C, and D, but that aspect has been withdrawn. Is that correct?
That's correct.
So turning back to the sole remaining aspect of contention 3, the Coastal Zone Management Act compliance issue, PG&E identified the Coastal Zone Management Act in its environmental report and included in the LRA a copy of the consistency certification that it submitted to the California Coastal Commission. And a cite, Ms. Curran, in the petition at footnote 37 seems to confirm that PG&E was required to submit nothing more than the consistency certification that it submitted to the application, or that it submitted with the application. So my question to you, Ms. Curran, and that cite that you all put in footnote 37 says, quote, applicants must submit to both the NRC and to the state a certification that the proposed activity complies with the enforceable policies of the state's program. If the Coastal Zone Management Act applies to the project, the NRC cannot issue its license or permit until the state has concurred with the applicant's certification of a coastal consistency determination. So my question, Ms. Curran, is what part of the Coastal Zone Management Act requires PG&E to have submitted anything more on the Coastal Zone Management Act with the application than it already has submitted? Where's the failing on the part of PG&E on the Coastal Zone Management Act?
The failing of PG&E is to receive approval from the California Coastal Commission of its certification.
Now, I understand that the Coastal Zone Management Act requires, ultimately before license renewal, a consistency determination either by the California Coastal Commission or the Secretary of Commerce. Are petitioners taking the position that that determination has to be included with the application? And if so, where is that? Because I did not find that in the statute or any of the regs implementing the statute.
I'm not aware of a regulatory requirement other than the NEPA requirement for including a copy of the certification, but the statute does require it. And our position is that the application cannot be approved without the consistency determination. I think that the arguments against admissibility of this contention are that it's premature and that we haven't reached the state yet where it's clear that it's not going to be approved. We feel that we have an ironclad obligation to raise issues as soon as we can identify them.
I understand that, Ms. Curran, but we have to justify in our decision, if we admit contention 3, we have to justify that PG&E hasn't done something that it was supposed to do. And as I read the act and the implementing regulations, it's done everything it was supposed to do at this point in time. And so how do we justify admitting essentially what would be a placeholder contention for the possibility that the staff would ultimately end up with a license renewal without a consistency determination?
We're not relying on the NRC's regulations regarding the content of license applications.
I understand that.
We're relying on an independent statute, a statutory requirement. Now, it is evident right now, because of the letter that was written by the CCC to PG&E in December, that the CCC does not consider the certification submitted by PG&E to be adequate. That is what we are relying on for our contention, that a statutory requirement that is essential for approval of the license renewal application has not been satisfied. And that's the basis for our contention.
Right? So, and just so I understand, the fact that the California Coastal Commission has come back and said to PG&E, you submitted this certification, we require additional information before we start our review time. That's what the petitioners contend PG&E somehow has not complied with some requirement because the Coastal Commission has come back and said we need more information?
The status at this point is that the certification, which has been submitted, has been rejected.
Well, I don't know that I agree with you that it's been rejected. There are, as PG&E cited in its opposition or in its answer, there are provisions dealing with essentially the rejection, which is the California Coastal Commission at the end of its time period says no. And a situation provided in the regulations that allows the California Coastal Commission to come back and say to PG&E, we need more information before we can start our time to review this. And that's how I read that letter that was submitted, because it specifically came out and said, our time isn't starting, you need to give us more information. I didn't read anywhere where it said, boom, no, you're not getting your consistency determination from us. So I don't know that I agree that the California Coastal Commission has denied it or rejected it. What I'm trying to find is, what is it that the statute requires that hasn't been done that would allow us to admit this as a contention? Because as I look at the status of things, PG&E has done everything that it was supposed to do. It's just working with the California Coastal Commission toward ultimately getting that consistency determination.
What we're trying to protect against here is, had we waited till later in this process, if there's still problems with this coastal certification, and we put in a contention, we would have thought, in all likelihood, we would get a ruling, you should have come in when you knew there was a problem at the very beginning. At the very beginning, you knew that this certification was not being accepted by the CCC. And now you've waited too long. This is a common experience of interveners and petitioners in NRC licensing cases. If you, the licensing board, want to rule that we're premature, we would appreciate guidance on what a timely contention would look like, because this is an ever plaguing problem as to know, to be early enough to raise issues when it's really not clear what's going to happen.
Well, I appreciate that response, and one of the things that I am learning after my recent appointment here is I'm not able to give legal advice anymore. So we can't give you any advice on that, but what I can do is ask a question that I had for the staff, which is, Mr. Wahatka, if we don't admit this contention, what is petitioner's remedy should PG&E ultimately not get that consistency determination and somehow the license renewal comes through? What should petitioners do?
Your Honor, Mr. Murphy is going to address contention 3 for the staff.
Sorry, Mr. Murphy, go right ahead.
Yes, Your Honor. And so there's a previous commission decision which kind of explains the correct remedy in that kind of a situation. I'll provide the citation for that for that commission decision. So North Anna Power Station Unit 3, there was CLI-12-14 decided in 2012. And so in that case, essentially the board took an approach which is kind of sought here by the petitioners. They decided to keep the proceeding open despite not having any live contentions with a set schedule, including some milestones such as the supplemental environmental impact statement and the safety evaluation report, to allow the petitioner to submit additional contentions as information became available. But in that case, the commission said, no, that's not the correct approach. The petitioner needs to pursue the motion to reopen, which is found in 10 CFR 2.326. And so that would be the appropriate remedy if that hypothetical situation came about. And there's two things I'd like to mention too, just to kind of head off that idea that the staff would go ahead and issue the licenses without California Coastal Commission concurrence or in the face of a rejection. So the first thing is there's a presumption of administrative regularity that the staff will fully and properly carry out its duties. And also, too, the staff faced a pretty similar situation like that in a recent license renewal proceeding. So for Surrey Power Station units 1 and 2, the record of decision was Mike Lima 2009 1 Lima 985.
Sorry, can you repeat that?
Yes, Your Honor. So Surrey Power Stations Unit 1 and 2, Mike Lima 2009 1 Lima 985. And so in that case, the applicant had not obtained the concurrence from the appropriate state agency by the time the staff completed its safety evaluation report and the supplemental environmental impact statement. But the staff held off until the applicant did obtain that before it issued the renewed licenses. And so there's not just the presumption, but also a recent example where the staff complied with the CZMA in that sense.
Counsel for PG&E, would you like to weigh in on, don't feel like you have to, but I want to give you the opportunity to weigh in on what the remedy would be if, in fact, we don't admit this contention. And not that we're saying the staff would violate and act not in conformity, but what would happen if, in fact, that happened?
Sure, and I think the staff is on the right track. The regulations in 10 CFR 2.309 Charlie provide for late filed contentions. Contentions can be filed later if new information arises that presents materially new information, such as the theory that the NRC chose willfully to simply violate the CZMA, because that's essentially what the petitioners are asking the board to admit a contention on, that hypothetical future potential material dispute where the NRC purposefully chooses to violate a statute. But if that were to happen, they certainly could come in with a new contention under 2.309C.
And just so I'm clear, as I looked at this particular issue, I mean, there was a commission decision in a PG&E Diablo Canyon case, CLI 1611, where the commission specifically noted that PG&E noted the NRC could not issue renewed licenses for Diablo Canyon without concluding that license issuance would be consistent with the Coastal Zone Management Act, which required the issuance of a state CZMA consistency certification. And the staff, in its standard review plans for environmental reviews for nuclear power plants, Supplement 1, operating license renewal, draft report for comment, New Reg 1555, Supplement 1, Revision 2, very long titles. Section 3.2.1, page 3-3, specifically addresses Coastal Zone Management Act and says a federal agency cannot issue a license or permit until the state concurs. So with that background, Ms. Curran, is there anything in the petition that you have raised that would lead us to believe that the staff is going to ignore its requirements and act in derivation of the law?
I just don't want to speculate about the future, and what we would really like is a ruling on our contention by the licensing board that would, we want to protect ourselves if we raise this issue in the future. for some reason or other. I don't know what it might be, but we want protection against any argument that we could have and should have raised something when we became aware of it.
I hear that, and I appreciate that and understand that, but my question is a little bit more specific. Because there is a presumption of regularity that attaches to the actions of government agencies, we have to look and say, absent clear evidence to the contrary, we presume that the staff is going to act and properly discharge its official duties. My question to you is there any clear evidence to the contrary that you've put in the petition that you want to bring to our attention that might allow us to get over that presumption of regularity?
No, we have not presented evidence of irregularity by the staff. I would like to ask Mr. Murphy if he could give that North Anna site one more time.
Yeah, so it's North Anna Power Station, Unit 3, CLI-12-14, and also 75 NRC 692, and it was 2012.
Thank you.
Do either of my colleagues have any questions about contention 3? No. Because we are running late in the day, I'm going to skip the conclusion on contention 3 from council, and we'll wrap that into the closing. But before we get to the closing, I just wanted to note that we do have a request by the CEC to participate as a non-party. I saw no oppositions to that hit the docket. But Ms. Curran, do the petitioners have any opposition to the CEC participating as a non-party?
No.
Mr. Leidy, same question to you on behalf of PG&E.
No concerns.
And Mr. Wahutka, same question to you on behalf of the staff.
No, Your Honor.
Thank you, counsel. All right. Before we close out the argument today, as I've mentioned a couple times, we're going to offer counsel up to 5 minutes to do any closing argument or closing summary to us. We have listened very intently to all of your arguments today, so please don't feel a need to repeat things that we have gone over. But counsel for petitioners, we would offer you the 5 minutes first, followed by Mr. Leidy, followed by Mr. Wahutka, and then Ms. Curran will go back to you with 3 minutes for rebuttal. If you don't want to use your 5 minutes, if you don't want to use all of your 5 minutes, please don't feel the need to take all 5 minutes. But if you do opt to take those, Mr. Welke will start the monitor on green. It will then go to yellow at 3 minutes, and then we'll count down to red. When it goes red, we'd ask you to please stop. So Ms. Curran, would you care for 5 minutes?
Judge Mercer, I don't have 5 minutes. I just would like to say that the petitioners have raised some extremely serious issues with respect to the safe operation, whether operation of Diablo Canyon will be safe during the license renewal term. We think, we appreciate the degree to which you have shown close attention to our concerns, and we hope that you will grant us a hearing on these very serious issues. There are many people, members of our organizations and other members of the public who will be depending on you to help us get at some of these serious issues and really air them. Thank you.
Thank you. Ms. Curran. Mr. Leidy.
Thank you, Your Honor. Just one wrap-up comment on the final contention, and then I'll give just a brief closing. We were discussing, the process and the precedent regarding premature contentions, and I think that the licensing board's recent decision in the Turkey Point SLR proceeding, LBP-24-03 at pages 29 to 30, talks about a similar circumstance. There it was where there was a required consultation that must occur during the license renewal application review process, something that goes on into the future after the application is submitted. And the board there found that a challenge to that process, when the process had not yet completed, was premature. And there's citations to other commission precedent there that may be helpful. But just to close very briefly, we've seen the many overlapping reasons that all three of the contentions are inadmissible here today as part of this license renewal proceeding. But we want to reiterate that Diablo Canyon is operating safely according to every inspection, every review that is done by the regulator. PG&E has followed regulatory requirements. Petitioners are certainly free to raise safety objections, and the fact that their contentions here may not be admissible in the license renewal process does not mean that no one is considering their concerns. There are just different processes, different avenues, and different pathways for them to raise those safety concerns. PG&E takes safety very seriously. It's its top priority. And so we don't want anyone to have the misunderstanding that by determining that a contention is inadmissible, that concerns are not being considered, because they certainly are by both PG&E and by the regulator. And for that reason, we ask you to deny the petition.
Thank you, Counselor. Mr. Wahatka or Mr. Murphy, whoever is going to be concluding, you have 5 minutes if you would care to use it.
Yes, Your Honor. Contrary to the NRC's license renewal framework, petitioners' arguments in contentions 1 and 2 effectively assert that Diablo Canyon's current licensing basis is unsafe, and not that any one of the many AMPs or TLAAs in this license renewal application will somehow not sufficiently maintain that current licensing basis. Therefore, these two contentions are not within the limited scope of this license renewal proceeding. Instead, such arguments are appropriately addressed through the NRC's ongoing regulatory process. And this has in fact already been recognized by the Commission, which referred the same arguments as those raised in contentions 1 and 2 to the NRC's 10 CFR 2.206 enforcement process, where they are being reviewed by the relevant staff experts right now, who will issue a written response, and the Commission may intervene in this process at its discretion. Nothing remains of these arguments to be addressed in this license renewal proceeding. And with respect to contention 3, there is not a live case or controversy that could give rise to the board granting a hearing in this instance. If any new facts were to arise, the regulations already address this. There's the 10 CFR 2.309C requirements for new or amended contentions, and the 10 CFR 2.326 requirements for motions to reopen. And so, taken together, Your Honor, since there has been no admissible contentions pled, the board should deny the hearing request.
All right. Thank you, Mr. Wahatka. Thank you also, Mr. Murphy, for your contributions as well. Ms. Curran, I promised you 3 minutes for rebuttal to anything that was brought up by Mr. Leidy or Mr. Wahatka. You
I have nothing further. Thank you.
Thank you. Before we close out, I want to let council know I did receive by email today a written limited appearance statement from an individual who purports to live in, I believe, Santa Barbara, California. That has been forwarded to for docketing. I believe it has been docketed, but I just wanted to let everyone know that that was received. It should be there. If you didn't receive email notice of it, please check the docket. It should be there under the written limited appearance statements. I also want to thank you, council, for answering our questions and providing us with your thoughts and arguments today. We truly appreciate your preparation, your hard work, and your professionalism here today. It helps make our job so much easier. We will consider your arguments and your thoughts in making our decision on the hearing request, which we intend to issue timely. On behalf of the entire board here, I would like to thank our law clerk, Ms. Newman, for her assistance in the matter, including preparing for the oral argument. We also extend our sincere thanks to Mr. Welke and to Mr. Deuker, our IT specialists, to Ms. Ellis, our program analyst, who you may have met before the program or the argument began, and to Ms. Culler, our litigation support assistant, for their technical and administrative support. Finally, we thank our court reporter, Mr. Owens, for his work here today. And we want to extend a special thank you to all of the experts who have been here, and also to thank all of the members of the public who have tuned in either on the webcast or the listen-only line, because transparency and openness is a cornerstone of the NRC's proceedings, and we thank you for taking advantage of that. Council, I'd ask you that you please remain here in the hearing room for any clarifying questions from the court reporter. And with that, we are adjourned.